Welcome to The Nation. I'm PASHA RAHIM. In today's global economy, insolvency crosses borders and so must the laws that govern it. Joining me to unpack this are THIYAGU GANESAN, Deputy Director General of Law Reform, Legal Affairs Division, Prime Minister's Department. He's also the chair of the Cross-Border Insolvency Reform Working Committee, along with AZNIZA Muhammad Ali, the head of Policy and Legal Division at the Malaysia Department of Insolvency. Welcome. Thank you for joining us on The Nation today. So we're going to try and understand this thing called cross-border insolvency. Now, we've heard of personal insolvency. We've heard of also corporate insolvency. Now, we're trying to understand today what cross-border insolvency is. Perhaps, Mr. THIYAGU, for viewers who are not very familiar, and perhaps also for myself, could you briefly explain to us what cross-border insolvency means?
Thank you for having us, first of all. Before to answer that question, it is important to understand two important concepts.
Okay.
First, what is insolvency? Insolvency means a company unable to pay the debts. So in Malaysian context, if you owes for 50,000 ringgit Malaysia and fails to pay, then it will then trigger a liquidation proceeding, which means insolvency proceeding, or we can go rescue mechanism such as corporate voluntary arrangement or scheme of arrangement. Okay. What is liquidation? Liquidation means a process where a company has been wound up and then the property and asset will be vested within the private liquidator or Director General of Insolvency being the official receiver to manage, realize the assets and pay off the dividends. That is insolvency primarily. That's his first concept. Second concept is what is cross-border insolvency. Cross-border insolvency means company occurs, for example, a company occurs to have assets or creditors or operation more than one country. That means we have two countries in place. So whenever the process between these two countries, that is what we call cross-border insolvency. Whenever there is no specific law to deal with these two countries, then it becomes a delay, inefficiency, and loss of value of the properties. Hence, this cross-border insolvency law become very useful mechanism to interpret certain principles.
Right, so this applies to companies that are registered both in Malaysia and also in the country where they run their business and where they have or they come across the issue of not being able to pay off their debts.
That's precisely.
Right. So today we're talking about cross-border insolvency, and there is a new law that is coming into play. We already have the Insolvency Act of 1967, and we also have a few provisions under the Companies Act as well, as we had mentioned, we talked about earlier before the show. But for the purpose of this discussion today, Madam AZNIZA, this new law that we're talking about, specifically the Cross-Border Insolvency Bill 2025. Now, what are some of the gaps that existed previously in our law framework or legal framework when dealing with cases such as this, and why is it necessary for us to have this new bill?
When we talk about cross-border insolvency, like what just mentioned about with Mr. THIYAGU, we talk about multiple judicial proceedings in other jurisdictions. So we are talking about global economy. There is the current trend now, where we have foreign investors, we have creditors outside jurisdiction, and when they want to invest our countries, they demand certainty, legal certainty. What will happen if businesses fail? Okay, and what are their rights and standing in the Malaysian insolvency proceeding? So before the introduction of this bill, we don't have any statutory framework govern insolvency proceeding in respect of corporate matters. So we have Companies Act, but there is no provision with regard to cross-border insolvency. And it is quite uncertain how insolvency practitioners, especially the foreign insolvency practitioners, when they come to our country, what are the areas that they have to look at, whether they have been granted access, what is recognition, are our courts ready to recognize their position here. And having said that, we rely much on committee principles and common law principles. And what is this committee principles? It is actually a legal doctrine, but it's non-binding. So it is left much to the discretion of the judges, whether to grant recognition, to grant access, or to refuse access. And there is this idea of legal sovereignty, and this bars recognition from being granted by the courts. So in that case, we need to have legal certainty. Next, we come to the judicial cooperation. There is a lack of judicial cooperation in this area to support our modern businesses working. So we only have one protocol with the Singapore Supreme Singapore Court, to be exact, and that is protocol communication court to court. How we communicate when dealing with insolvency proceedings with regard to between Singapore and Malaysia. But that is the only thing that we have. So moving forward, we need to have this law. This law will bridge the gaps that with regard to legal certainty and also judicial cooperation.
Right, so we're also talking about protecting companies or businesses in both countries, regardless if it's Malaysia or Singapore, if you're talking about trade in other countries as well, right? If I'm understanding this correctly. Okay, so why now? Why is now the right time for us to introduce this law? And perhaps you could give us an example. Has there been any recent cases or developments that has highlighted the urgency for this law to be in place?
Thank you. Just to answer that particular question, there isn't any particular case that triggered for this reform.
Okay.
I mean, generally, we based on the UN Citral Model Law. For our case, UN Citral Model Law has been adopted more than 60 countries, including US, United Kingdom, Singapore, Japan. In fact, in ASEAN member states, Myanmar and Philippines also have adopted the model law on UN Citral cross-border insolvency. So that is number one, because they wanted to align with the global best practices. Number two, the Right Honourable Prime Minister and Dato Sri Azalina Othman Said, and also supported by Minister in the Domestic Trade and Cost of Living, they wanted our side to do a commercial reform in a broader perspective. This commercial reform is actually meant to attract the foreign investment to come into our country, and also to ensure that our economy is become a more competitive economy, and also aligning with best practices so that we can bring more money into our country by having a clear, predictable model. I wanted to share with you this particular bill has been introduced, now already went through the successfully at the House of Representatives, now pending for the House of Senate. There are 5 main objectives why we need this law. Number one, this particular law will create a great cooperation between courts and competent authorities when it comes to cross-border insolvency.
Right.
Number two, it gives us a greater legal certainty for trade and investment. Number two. Number three, it is also to ensure that fair and efficient administration of the insolvency cases that protects the creditor's interests and also other related party, including the debtors. Number four, this is also to provide for the protection and maximization of the value of the debtor asset. Lastly, this particular brand new law also will facilitate the rescue of financially distressed company, thereby it will protecting the investment and also preserving the employment. So these are the main 5 objectives. So ultimately this law will create a clear and predictable model. So the people outside there, the investor, the business communities will come to Malaysia to take a chance and invest in our country. They know that our law is very clear in terms of doing in the even company has a financial problem, how to deal with it. If the company cannot survive, then go to liquidation, at least the creditors get back the money. So basically these are the 5 objectives. In fact, these 5 objectives have been stated in the Blue Bill itself, has been tabled by the Minister, Dato Sri Azalina Othman Said, recently.
Right. So just to be clear, the scope of this Cross-Border Insolvency Bill 2025, it only applies to corporate debtors. There are exclusions. Perhaps, Madam AZNIZA, you could clarify to us to whom this bill does not apply to.
So the objective of the bill is to serve the commercial transactions, companies, corporate insolvency. So it does not apply to individuals.
Right.
It does not apply to LLP, and it also does not apply to financial institutions, because these financial institutions, they have special regime dealing with insolvency matters. And we also have, apart from restrictions of entities, we also impose restrictions in terms of transaction, by looking at transactions, which means that if any transactions which have legal effects or economic impacts with regard to our economic stability, and this involves the provision set up by the Bank Negara and also the Securities Commission. So in other words, in drafting this law, we look at many angles. We look at issues of public interest and the economic stability, and also whether this law can serve its objective to support our business environment.
Right. So just to be very clear, if I have somebody who owes me a large sum of money in Singapore on a personal capacity, I cannot use this law to recoup my losses.
Yes,
that's correct.
Yes.
That's very correct.
just to get that very, very clear. Okay, let's talk about the UN Citral Model Law, which you mentioned earlier. Now, we've adopted this model law. Why is this very significant, and what does it mean in terms of our position on the global legal landscape?
To answer that question, we have to understand model law is just model law.
Okay.
It is up to any sovereign nation whether want to adopt or not to adopt. What is the benefit specifically we can gain by adopting this model law is that certainty in terms of global structure. That means A country will have similar approach with B country. C country will have similar approach with the D country. So what is most important? Number one, it will enhance global alignment. When it enhances the global alignment, the affected parties, whenever they go, they know this is the structure, this is the procedure, I'm going to get apply like this, and the court has power to recognize and grant this relief, and also the court also can coordinate and cooperate. So number one, it is actually to give a specific alignment with the best global practice by adopting this model law from the UN Citral. Number two, we are as ASEAN chair for this year, we able to show to outside there, the communities, ASEAN member states, Malaysia is actually promoting a best law that promote or fostering the trade and investment in this country. So this is the right movement for us to showcase. Number three, it also will enhance the cooperation between courts, A court to B court. So Malaysian courts also can cooperate with B courts in Singapore. And similarly, also to cooperate with Vietnam. By having this model, it will enhance the court cooperation. Primarily, these are the things that adopting UN Citral model law and the benefits. And of course, by having them on board, any expertise, any guidance, we can go back to them because they have real cases that they have experienced, and it can be useful for us to use it for our national position.
Right. Speaking about that, so this new bill now aligns our country with over 60 countries that also follows this
right.
UN Citral model law, also bringing us closer in line with countries like the UK, Australia, and also Singapore. Now, what are some of the lessons that we can draw from their experience that we can apply to the bill that we have just passed?
You said just now, the United Kingdom, Australia, and Singapore, they have adopted this law. So adopting the model law align our corporate distress legal framework with the standards of these countries, and these are developed countries. So in drafting the law, we made reference to the best practices, and these three countries are our main references. And we learned that the model law is not a one-size-fits-all solution. So by saying this, there is a need to balance international interests together with our domestic interests. And by looking at these countries, they have demonstrated that some modifications to the model law are necessary, but we definitely have to preserve its core principles. And when talking about modification, we tend to go to the issue of protection of national interests, protection of vulnerable creditors, and Therefore, we look at Singapore. Singapore made exemption. The law does not apply to individual bankrupts. So, and so in drafting this law, we also made some modifications to it. And basically, we are also imposing restrictions just to protect our economic stability.
And the minister also have the power to expand the list provided under the current list under the legislation, meaning to say that we already have certain exemption list that has been provided as mentioned by Puan AZNIZA. At the same time, there is a power for the minister to extend, but upon recommendation and suggestion from the various agency, to protect the national interests.
The flexibility.
The flexibility.
Yes.
Right. So, given that this model law, it's widely used in advanced countries, what do you think are some of the challenges that we here in Malaysia might face?
I think, in my perspective, the awareness among the legal practitioners how to use this law. It's a brand new law, and there are practitioners from the IPAM, MIA, MICPA. There are a number of organizations and certain law firm and legal professionals already in the know about existing of this law when coming into the force later. However, we have to move this aggressively in order to have a better understanding how this law works. That is the biggest challenge. Number two, if we don't have this law in place, another challenge is we will be losing the asset. People will go and hide the assets, and the insolvency practitioner cannot act very fast in order to trace back the assets for the benefit of the creditors. End of the day, the creditors will lose the money. If creditors lose the money, the economy will not have money in order to cycle it for the betterment of another businesses. So it is entirely one cycle, you see.
Right.
Because the law itself, it introduces new concepts to our corporate legal system. Concepts like a center of main interest. How do you determine center of main interest? What is the difference between center of main interest or COMI with establishment, while is main proceeding? So they need to learn all these new concepts.
Absolutely.
And next, it comes to implementation.
Right.
How the court communicate with each others. How we do a coordination of proceedings to conduct multiple proceedings. So there are the challenges that we might face once the law comes into force.
Right, so lots of homework for all of our corporate lawyers out there. Speaking of, the ASEAN Law Forum is also coming up later this month. Perhaps you could share with us how this new law ties in with Malaysia's role in also helping to shape regional legal practices and also legal cooperation within the ASEAN region.
Thank you for that question. It's a very important question for us also to promote this ASEAN Law Forum. It's going to be happening next week. ASEAN Law Forum, for the first time coming, Malaysia is having it at our homeland from 19 August until 21st of August. Various topics going to be discussed, not only cross-border insolvency, but online safety, arbitration, mediation, business and human rights, criminal law reform, commercial law reform, name it. So many areas that we're going to discuss for the 3 days. But what is important for us to understand this particular concept of ASEAN Law Forum is that a gathering of intellectuals to discuss various topics, and the special advisor Yang Arif Tan Sri Nalini, the federal court judge, also joining us for the cross-border insolvency topic on that particular day, and also to show the ASEAN member states outside there that Malaysia is having the good law that will that is friendly to the investment, bring back business to Malaysia, and also to enhance our legal cooperation within our ASEAN member states.
Right, so from the 19th until the 21st of August. Anyone out there who finds, if you find yourself to be in a legal pickle, that's a good place to be during those 3 days. Let's talk about implementation and also the impact of this new law. How will this law work in practice? Now, particularly in recognizing foreign insolvency proceedings, and also there needs to be some measure of coordination between Malaysian courts and foreign courts. How is that going to happen in practice?
Generally, for this particular law, Puan AZNIZA, and she can confirm later, there are 4 key principles. One is actually access. Number 2 is actually recognition. Number 3, relief. And last one is actually coordination and cooperation, as I alluded earlier. From this particular bill, we have specifically have part 5 and part 6 that talk about cooperation within foreign courts and foreign representatives. Meaning to say, court to court, how to cooperate, number 1. Court to foreign representative, how to cooperate, number 2. Number 3, foreign representatives to foreign representatives. So all procedure has been clarified clearly in this legislation.
Right.
By having this clearly in place, it will enhance better cooperation and coordination. Eventually, who will get the benefits? The businesses, the financially distressed company will get benefits, and eventually the creditors ultimately.
Right, so it's not as simple as just sending each other a WhatsApp message. Okay, from the perspective of the Malaysia Department of Insolvency, how is this law going to change your day-to-day handling of cases?
Yeah, I think the first thing we need to note is that corporate insolvency administration is no longer territorial. So we are now looking into international context. So our role will shift from primarily administering domestic insolvency cases to one that involves greater international cooperation and coordination. And we have now new legal duties. As the official receiver, we will participate in foreign proceedings. Our officers need to understand the new context and how to navigate with foreign legal systems. And definitely we have to set up new procedures, how we will conduct communication and cooperation with foreign creditors and foreign courts as well. And definitely we need to establish a special unit dealing with cross-insolvency matters because this is new to us. And how are we going to administer cross-border assets? That will be a new challenge to us. So, and it goes back to training. We need to provide training to our officers so that we can implement this law effectively.
Right. Mr. THIYAGU, as with all laws, there will be people who will be looking for loopholes. Now, are there safeguards in place to prevent the misuse of this cross-border insolvency bill, or, you know, just maybe some companies who might try to use it to avoid certain obligations under Malaysian law?
Certainly. I mean, generally, if we go back to the UN Central Model Law, we have Article 13 that says that foreign creditors will get same treatment with unsecured creditors of Malaysia. And the priority list under Section 5 to 7 of the Companies Act 2016, Act 866 doesn't change. It remains there. There are a number of safeguards that we put in place. Name it Clause 3 sub 2 of the bill says that no exemption, which AZNIZA alluded earlier. Number 2, we have Clause 4 that says that have to be in line with and the procedural law have to be in line with the other existing law in Malaysia. That means you cannot override the existing law in Malaysia. Number 2, safeguards. Number 3, that the court cannot give any relief or recognition or even coordination and cooperation if it is contrary to public policy. The one, number 3.
Right.
Number 4, we have also protection for the local creditors, smallholder creditors, that if you want to bring back the assets outside of the country, you have to get leave from the court, and also subsequently you have to also allocate certain sum for it. Last one, there is a specific provision, Clause 22 says that the court has the power to look after the interests of all creditors, including secure creditors, unsecured creditors, other related parties as well. So there are a number of safeguards in place to prevent the misabuse that you were mentioning earlier.
Okay, so when we're talking about you know, having these laws in place, obviously we're going to what we'd like to see is an increase in investor confidence. How do you think this is going to impact foreign investor confidence, and also Malaysia's reputation as a whole as a business-friendly and very welcoming jurisdiction?
Yes, my answer would be the bill is significantly will enhance Malaysia's reputation and boost foreign investor confidence. Because how it impacts investor confidence, we look at the objectives of these bills. Okay, the first one is to have legal certainty. What will happen? We give assurance to the foreign investors. What will happen if businesses fail when a company have to deal with insolvency, and we tell them that there is equitability treatment of creditors. I mean, you are now have your rights here. you can participate in our local insolvency proceedings, or in fact, we will recognize your foreign insolvency proceedings. Next, asset preservation. And this is what we are looking at. If you want to rescue businesses, assets in multiple jurisdictions, they need to be traced and they need to be realized so that it can benefit the creditors, whether it is local creditors or foreign creditors. And definitely, such an environment would support business rescue and also business transaction in the world. Yeah, we talk about global economy.
Right. This has been a very enlightening session for me. Now I have a better understanding of cross-border insolvency. Last question, very quickly, Mr. THIYAGU. Looking ahead, how do you envision this law strengthening Malaysia's international legal and also business credibility, say, within the next 5 or 10 years?
I would say that this particular cross-border insolvency legislation, the Bill 2025, is sending a strong message to outside there, to general public, entire world, that Malaysia is actually preparing and actually for the fairer and modern and globally aligned standard laws that to attract investment coming in, align with what the Right Honourable Prime Minister is actually going around to overseas and bringing back the investment to our country and attract more investment. I think this is a strong message, and I think many people will agree to this.
Fantastic. Thank you, Madam AZNIZA, and also Mr. THIYAGU for spending your time here with us today. That was THIYAGU GANESAN and also AZNIZA Muhammad Ali on Malaysia's cross-border insolvency reforms. A strong reminder that in a connected world, our legal frameworks must also be just as connected. I'm PASHA RAHIM. Thanks for watching, and be sure to follow us for more in-depth conversations on the issues that matter. I need to go and get a drink. Thank you.
Demi negara, kami bersedia menghadapi apa jua kemungkinan. Kami terus siaga, lindungi negara sepenuh jiwa dan raga agar rakyat aman dan sejahtera. Di darat, di laut, di udara, kami mara melangkah dengan satu tekad, dengan satu keazaman menuju